If you're reading this page, chances are you're actually a family member or a friend of somebody who's already been convicted. I say that because areas of criminal law involving sexual offences often result in lengthy prison sentences. So if somebody's been convicted, they may well already be in prison. And being in prison, it's very difficult to have access to new solicitors. So I'm often contacted by family and friends of people who have been convicted. So what can be done in relation to an appeal? Well, there's a lot. First of all, if the person has been convicted, they will already have had, usually already had legal advice. They will have perhaps had legal aid. They will have already been told that they have got no grounds to appeal, and they've been convicted and they may well be in prison. And you may think that's the end of it because one lawyer has said, case over, you've got no grounds to appeal. But don't just sit back and accept that. The firm that's just represented you or represented your friend or loved one may well have behaved incorrectly, may have got the law wrong, may have not taken steps they should have done, may have missed evidence. It could be the mistake of the judge, maybe an error in summing up, may have got the law wrong itself. The lawyer that's already represented you may not tell you those things, may not know those things, may not be aware of them. And taking a fresh opinion can often help. If you think about a medical problem and a doctor tells you you're okay, you may not just want to accept that medical result. You may want a second opinion. And you can do the same thing with law. And so what do we do in relation to an appeal? Well, first of all, we want to look at, do you have grounds to appeal? We need to split it into stages. It gets very complicated, so we need to take it step by step. The first step is assessing whether you have grounds to appeal in the first place. So when we take on an appeal case, we go right the way back to the beginning. We look at all the evidence, we look at the procedures that's taken place in court, we look at what your previous firm has done, what the solicitor has done, what the barrister has done, what legal arguments were raised or not raised, what the judge said in the courtroom. We may need to get the transcript of the hearing. We go through absolutely everything. Not just me, but my team, we go through it all properly. So we're looking for every possible avenue that we could go down to try to find grounds that would give you the right to an appeal. Once we have a good feel for that case, we then bring in one of our specialist barristers who will advise specifically in relation to the appeal and whether you have grounds to an appeal. So we look at perhaps 3 or 4 people going through your case to try and find the grounds to appeal. And the point of doing that is it saves you money, because if we conclude that there are no grounds to appeal, at least we can tell you that, and we can explain why there's no grounds to appeal, and that might give you some peace of mind, and it limits the cost to you. However, if we do find grounds to appeal, because we've spent so much work going through everything properly, then we're fairly certain, in our view, that you have got a good case to appeal. We'll explain that to you, and then you decide whether you want to carry on with that appeal. And then you're into the next stage. Okay, so all the first part is the assessment of the case, going through everything properly and working out whether you have grounds for an appeal. We can often do that work on a fixed fee, and we'd be happy to chat through your individual circumstances and explain that cost to you. If we find that there are grounds to appeal, then there's different routes to appeal. The majority, I suppose, that we would deal with, somebody who's committed a serious sexual offence, for example, being convicted. A case we had out with recently, a client received 15 years in prison. We took on the case, we found grounds to appeal, we filled in the appeal application, we requested an extension of time to appeal because there is a very limited time in which to appeal, and most people are outside that time anyway. If you think about it, if you've been convicted, you then sentenced maybe a month later, you're then settling down, your family's getting your head around everything, and it can be a good couple of months later before they contact solicitors. It might be another month, 2, 3 months before we've assessed all the case. So in almost every case, we're out of time. It might be 28 days to appeal from the Crown Court. So there's very limited time. So we can make an application to appeal out of time. That's normally granted. And once the appeal's going forward, we're then looking at how do we convince the court to set aside that conviction. And that can be done with paper application, often on papers. You may not need to attend the appeal hearing. And if that appeal is granted, the conviction can be quashed straight away. And in the case I mentioned a few moments ago, a client who received 15 years, within 2 months, I think it was, of dealing with the case, the Court of Appeal had quashed that conviction. He was released straight away. The court will then decide whether there should be a retrial. And if they say, yep, it's up to the prosecution will decide whether there's going to be a retrial. Either way, it's a win-win situation from your point of view, because you're usually released pending the appeal, and there may be no retrial. But if they do want a retrial, if the prosecution does decide it wants a retrial, then at least you've got another chance. You go through the whole thing again. It's a fresh trial. Everything's dealt with from the start properly. And we can also assist with that case going forward. It helps because if we spent all the time and the energy going through everything from day one, looking at all the evidence afresh, and we're able to convince the appeal court to release you and to give you a retrial, then we're in the best position to then argue the case properly going forward. So there are additional costs for that work, as you would expect, but please contact us. We'll do an assessment of your case and explain what those costs are likely to be. The initial assessment is always free of charge anyway, so please get in touch. We'd be happy to help you.